So my name is Hannah, and I'm the marketing manager at Elegant Law. So I help organize these events and webinars. And today we have Andrew, who is a partner in our labor and employment groups, and he's going to be talking about rights after you've lost your job, essentially. So thank you for joining us. We really appreciate you taking the time, and we hope that you can find some useful information from the session. So just a couple housekeeping items before I hand it over to Andrew. So the Q&A will be enabled throughout the session, and I'll just make sure that the anonymous question asking is toggled on. So it's totally anonymous, and you can ask questions throughout the session. They'll pop up for Andrew so he can see them and address them as we go. And then we will also be sharing a recording of the webinar as well. So if you maybe were late or you want to rewatch it or you want to share it with someone who's in a similar situation, we'll send an email to everyone who signed up probably tomorrow with a recording of the webinar, and then also the contact information for Andrew, as well as our employment law intake clerk if you did want to get in touch with us about setting up a consultation. So I'll make sure to send all that info to registrants after we're done. Yeah, and that's basically the logistics and housekeeping from me. So I'll just hand it over to Andrew to get started.
Thanks, Hannah. And as Hannah said, feel free to use the Q&A to ask any questions you have. Doing this to try and provide as much information as we can for people, because I'm sure some of you have some pressing questions, and some were sent in advance. I think we have like 5 or 6 that were sent in advance, and so I will either sort of hit them as I'm going through the presentation, or when I get to the end of it, I'll quickly run through them to make sure that I answer all of those. So as Hannah said, my name is Andrew. I'm the partner and practice group leader of the Employment and Labor Law Group here at Elegant Law. And we are a full service firm, but we have a large employment and labor law group that for years has helped Ottawa employees in termination situations, group terminations, and similar circumstances. And recently, especially in Ottawa and especially, in the tech sector, as well as some other sectors, there has been some large layoffs and an increase in layoffs, or maybe some of you are just sort of worried about the fact that you may be facing a layoff in the future or a termination just because of AI or the economy or whatever reason. So we're here today to provide some legal information about your rights and entitlements on termination. And I want to be clear, we can't provide legal advice. So I can't tell you what you are individually entitled to, if you are fired. However, I can go through generally what people are entitled to if they are fired to help give you sort of the background on how the law protects people who lose their job in a termination, so you can kind of decide whether or not that's something you might want to think about getting your own specific legal advice, either from us or some other law firm. So I'm going to sort of start very, very high level by talking about termination rights more generally, and then move into some of the specific types of compensation that people are actually entitled to when they lose their job. After that, I'm going to talk about what some of the restrictions are to that compensation or the ways in which that might be lessened or reduced. I'll talk a little bit about how you pursue claims of wrongful dismissal or improper termination in the event you are let go and your employer hasn't offered you some sort of fair compensation. And then I'm going to talk a little bit about what the process is for negotiating or improving a severance package. And if you can't negotiate or improve your severance package, kind of where you go from there, which is, basically needing to sue your former employer. And then finally, I'll deal with any of the questions that were sent in advance. But like I said, if you have a question as I'm going through it, feel free to use the Q&A, and I'll do my best to answer the question kind of as it comes up. So starting with termination more generally, in Ontario and frankly in Canada, for the most part, private sector employers can fire people for virtually any reason under the sun. The caveat to that is they have to provide the person with compensation as a result of the termination of their employment. So the compensations, you may have heard the term severance, notice, those types of terms, but that's just another way of saying they have to provide you with some form of compensation if they terminate you. The exceptions to that are if the employer has cause. So cause is you have engaged in behavior that is so terrible that no court is going to make an employer keep you employed. So fraud, theft, serious harassment, serious sexual harassment, abusing your position or your authority, like things that are sufficiently serious that a court goes, you know what, employer, you can fire this person, and we don't think it's fair to the employer to make them have to pay some kind of severance in the circumstance. However, courts have made it very, very clear that cause is a high bar for an employer to overcome. And so often, even when an employer has concerns about an employee, or even if there was some kind of misconduct, the employer will not assert cause because it's very, very difficult for them to make out. And they could be met with an allegation of bad faith behavior in the event they allege cause, and actually the behavior wasn't that bad. And courts don't like employers who allege cause because, like I said, the employee gets no compensation after losing their job, and courts don't like to leave people in that position. The other sort of broader exception to that is, human rights protections, workplace health and safety protections, or if you're a unionized employee, there's completely different rules that do create situations where maybe you actually cannot fire someone. So, for example, if somebody's on a protected leave because they're on maternity leave, there are very limited circumstances in which an employer could actually fire that person. Similarly, if you make a workplace health and safety complaint, an employer might not be able to fire you in that situation. But again, those are sort of the exceptional cases. For the most part, any one of us could be let go from our job at any point, as long as the employer provides us with compensation. That's the only sort of caveat. And so one of the main things that an employment lawyer does when we meet with someone who's been let go is try to quantify, well, how much compensation are you entitled to? Your employer has called you into a meeting, or maybe a group of you into a meeting, and said, unfortunately, for business reasons, the economy, whatever it is, we need to let you go. You then need to be able to understand, well, what am I entitled to? Because there's a good chance that when the employer let you go, that they're actually making an offer to settle your termination at the same time. They'll usually hand a termination letter that says, we're going to give you 12 months of pay, or 6 months of pay, or 18 months of pay, or something like that. And it's important that you understand, okay, my employer's saying I get 12 months, but what am I actually entitled to? If I'm going to sign away some rights to take this 12-month payment, I might want to understand what my sort of best day in court is, or what I might be able to get if I try to negotiate an improved package. And so to figure that out, what lawyers do is we look at three different sources of compensation for employees. The first one is the Employment Standards Act. The Employment Standards Act is the legislation in Ontario that sets out all of the minimum rights that every single person working a job in Ontario gets. So think about minimum wage, hours of work rules, what vacation days you get. All of those things are set out in the Employment Standards Act because the government of Ontario has said every single person, no matter what, gets these basic rights. They've done the same thing with severance entitlements. And so under the Employment Standards Act, there is a minimum amount of severance that has to be paid. The second thing and I'll get into that in a sec. The second thing that a court will look at is, what does the person's employment contract say? Do they have a contract of employment with the employer that sets out some other period of notice? So that's the second place they look. The third thing they look to is the common law. So the common law is judge-made law. And what have judges said that people should get when they've been terminated? So to be clear, you don't get all three of those things. You basically get the greater of those three things, or some of them sort of are stacked on top of each other, but still you just get the greater of the two numbers. But those are sort of the three things we look to: the Employment Standards Act, the contract, and then the common law. So starting with the Employment Standards Act, it's really straightforward to calculate. You get a week per year of service of what is called termination pay, and that's up to a maximum of 8 weeks. So if you've been working somewhere for 6 years, you get 6 weeks of termination pay and benefit continuation. If you've been working somewhere for 10 years, you get 8 weeks of termination pay and benefit continuation. So that's the first amount you get. Some employees get another amount that's called severance pay, and this is Employment Standards Act severance pay, because the word severance gets used pretty loosely by lawyers, but in any event, it's called ESA severance pay. That is another week per year of service up to a maximum of 26 weeks. So, but first of all, you have to have worked somewhere for 5 years. People who work for 4 years don't get severance pay, and your employer has to have a payroll of over $2.5 million or 50 or more employees, which does capture a good chunk of employers. So, for example, If you work somewhere for 4 years, you get 4 weeks of termination pay and you get no severance pay because you didn't meet that 5-year threshold. If you work somewhere for 14 years, you get 8 weeks of termination pay because, like I said, it's a cap of 8 weeks. And then you get 14 weeks of severance pay on top of that. So 8 plus 14 equals about 22 weeks of time. So the Employment Standards Act are the floor. They're the minimum amounts everybody gets. But for longer service employees, it can end up being a decent chunk of change. It can go up to about 34 weeks worth of compensation. The second thing we look at is what somebody's employment contract says, because what courts have said is that, look, an employee and an employer can agree to some other amount of severance if they do so sort of proactively in advance. However, there are some rules that go along with it, which I'm not going to get into all of them because that would be like a 3-hour seminar. But one of the basic ones is it has to be at least your Employment Standards Act amounts. So, for example, for an 8-year employee who might be entitled to 16 weeks under the Employment Standards Act, you can't agree with your employer to a contract that says you're only going to get a month of pay or 4 or 5 weeks of pay. That falls below the Employment Standards Act, and so that contract would be deemed illegal. And actually what happens is you get the common law if your contract is deemed illegal, which I'll talk about in a second. But as long as it meets sort of your basic statutory entitlements, your employer may have put something in your employment contract when you started your work, or maybe you signed something midway that restricts your right in some way. Now, sometimes it can be bad. It can be, that it limits you to close to or exactly your Employment Standards Act amounts, which is, again, the floor of what you might be entitled to. Sometimes it can actually be more generous, too. Sometimes employers will put in clauses that say, hey, look, you get a month per year of service, or you get 2 weeks per year of service, but a minimum of 6 months as a starting point, or something like that. So you always have to go take a look at your contract, because just because you have a termination clause doesn't mean it's necessarily going to be a bad thing. There's another good thing about termination clauses that I'll talk about in a minute, but the amount that you're entitled to isn't reduced if you find a new job, which it is for the third category, which is common law. So common law is what judges have said people get. Judges generally are more generous than the government of Ontario in the Employment Standards Act, and they're generally more generous than what your employer is usually willing to put into an employment contract for obvious reasons. How judges decide what you get is they look at your job duties, your age, your years of service, how hard the job market is. Do you have any, restrictive covenants that prevent you from looking for new work? For example, if you're not allowed to compete against your old employer, various factors that might either lead you to needing more time to look for a new job or less time to look for a new job. And a court's going to say, how long roughly do I think it's going to take this person to find a new job? So it's a much more contextual, fluid test in terms of the amounts you're owed. However, there are some sort of standards around it, and most lawyers will tell you that, look, it usually works out to about a month per year of service. That month gets adjusted up or down based on certain factors, such as, older employees get higher notice periods. Often more senior or C-suite people get longer notice periods, although that's up for debate. Not everybody agrees with that, and not all judges agree with that. But they look at those factors to sort of establish, okay, this is how long we think that person is going to need to take a job. So, for example, somebody who's like 58 years old, has worked with the same employer for 16 years, is in an industry that's dying or fading, or the ability to find work is going to be quite difficult. A court might award that person 18 to 20 months of notice. Similarly, somebody who's like got 12 years of experience, but they're 36, job conditions are great, good chance they're going to find new work, they may award them less than a month per year of service because their age is lower, they're likely to find new work, things like that. So it's a little bit harder to predict with any certainty for any person what they might be entitled to, but that's roughly how that's done. So those are the three amounts: the Employment Standards Act, contractual, and the common law. And usually what most employees want is the common law, because it tends to be the most generous, and especially longer service employees. If you've been somewhere for 25 years, there's a good chance you may be entitled to up to 24 months of notice. There's no cap on common law notice, but courts have kind of imposed a cap of about 24 months. So it's not, there's some cases that say it explicitly, others that don't say it as explicitly, but there's very few cases that have gone over 24 months. The one big caveat, though, that you have to think about with your common law notice period, because I see a lot of people and they get sort of like really encouraged when they hear, oh, I might be entitled to 18 months of notice. That actually might, protect me pretty well, and it's going to give me time to find a new job and so on. Is courts have also imposed what's called a duty to mitigate. And what your duty to mitigate is just lawyer speak for the fact that when you lose your job, you have to take reasonable steps to find a new job. And usually when I say that to clients, they're like, of course I need to find a new job. I need to eat and take care of my family and. But what it means at law is if you don't take reasonable steps to look for a job, or you can't prove that you took reasonable steps to look for a new job, the employer is going to try and argue that you failed in your duty to mitigate and your notice period should be reduced. So instead of getting like an 18-month notice period, the employer goes and they argue, I think if they had looked harder for a new job, they would have found new work at 12 months. Court, we should only have to pay 12 months. And so that is one of, frankly, the biggest risks that people have when they lose their job in terms of what they might get as far as their severance package, is the risk that they find a new job. Because if they do find a new job, what a court does is they reduce your severance or your common law entitlement by any earnings you have during that same notice period. So let's use the 18-month example to help illustrate this. So somebody is entitled to 18 months of severance, but they start working after 12 months, and they earn roughly the same pay that they earned before. What a court would say is that employee is, on paper entitled to 18 months. However, the employer only has to pay them for 12 months because they found a new job. And so that is a reason that maybe some people would ultimately agree to resolve their severance claims or their wrongful dismissal claims against the employer for less than their full entitlement. Is sometimes what they can do is they can resolve it and sign a contract that says, I'm going to get a certain amount no matter what, even if I find a new job. So it allows you to kind of get the best of both worlds. You get your severance from the old employer and you're free to start working somewhere else, and you can kind of double dip or earn two paychecks for sort of the same period of time. But it is a big risk for people, because if somebody, comes to me, they're really long service, they might have like a strong entitlement to 24 months, but they also tell me that an old manager has called them up and said they have an opportunity for them and it starts in 2 weeks. All of a sudden their 24-month notice period just dropped down basically to their Employment Standards Act minimums. So, you always have to be aware of that and be aware that that might be the thing that sort of limits what you can ultimately recover against your old employer. Two other just quick points about the duty to mitigate. One is it does not apply to Employment Standards Act amounts. You are entitled to your Employment Standards Act amounts on termination, even if you start working the next day. Those are not subject to the duty to mitigate. Secondly, courts have also said the duty to mitigate does not apply to contractual entitlements. So if your employment contract says you get 6 months, generally speaking, you are entitled to that 6 months even if you find a new job or you mitigate. So those are two little exceptions to the duty to mitigate, which is Employment Standards Act amounts and contractual amounts, but it applies to the common law. So in terms of what you're entitled to as far as notice goes and as far as common law notice goes, the obvious things are, your salary and your benefits, or damages in lieu of your benefits. So maybe they didn't keep your drug plan in place, but you can be awarded damages from a court, or money to compensate you for not having your damages in place. Or if you need your wisdom teeth removed while you're in your notice period and your employer ended the benefits, you can hand the bill back to your employer and say, thank you, you owe me my dental coverage because you didn't keep my benefits in place. In some cases, it can include bonuses. It depends on what your policy says, how regular it is, what your employment contract says. In a lot of cases, it includes commissions if you're a salesperson. Not always, but generally speaking, that would form part of the equation. In some cases, it may include equity, RSUs, or other types of sort of share type compensation, and any other compensation, cell phone allowance, car allowance, gas allowance, clothing allowance, things like that can sometimes also be included during a notice period. So it's not just necessarily 12 months of base salary. Sometimes it can be 12 months of base salary plus benefits, plus sometimes pension continuation or group RRSP continuation during that period of time. There's a whole other, there's a lot of other aspects to your compensation that may be included in that. So that is, frankly, that is at its core what most wrongful dismissal actions are about. It's about what is your notice period going to be? Do you have an employment contract? Is the employment contract enforceable? If it's not enforceable, you're entitled to common law, or if you don't have an employment contract, you're entitled to common law. And most of what a lawyer is going to do is explain to you, this is what your entitlement is in these situations. However, there are cases that don't meet that pattern. And so sometimes we get people who, like I said, it's just a straightforward termination. It's a cost issue, and the employer had to get rid of a bunch of people. However, sometimes we have clients who come in with additional issues. It may be a human rights issue where they say, hang on, I was fired because I asked for accommodation for my disability, or I was sexually harassed, or I was treated differently based on my race, or I spoke out about a political issue that's connected to my personal identity, and I'm getting let go. So it maybe it's not just a straightforward termination. Um, we represent people who have been harassed or filed regular harassment complaints and have been terminated, or maybe a subordinate filed a harassment complaint against them, and instead of investigating the complaint, the employer fired the alleged harasser. And we also have cases where the employer possibly acted in bad faith. They fired someone, alleged they did some kind of wrongdoing and hurt their reputation, or there was an allegation against the person and they didn't investigate the allegation and instead just fired them, and it sort of left their reputation in tatters because everybody else sort of assumed the employer had figured out something bad had happened and that's why the person got let go. And in cases like that, you may have additional entitlements to compensation. That could include human rights damages. So again, if you're fired because of a disability or you're fired because of your sex or your race, that might be an additional head of damages you can seek. Bad faith conduct can lead to what's called bad faith damages or punitive damages. So bad faith damages would compensate you for any additional suffering you incurred. If there was a medical consequence of the employer's behavior, if it caused, a mental health issue or insomnia or other sort of medical consequences because of the employer acting badly, that is something you can seek compensation for. Harm to your reputation, things like that. So those are sort of connected to the actual harm you suffered because of the employer's behavior. A court could also possibly award what's called punitive damages, which are literally to slap the employer on the wrist for behaving badly. So it's not tied to your level of suffering or what happened to you. It's meant to deter the employer from doing that again or from similar employers doing that again. So that's also a different head of damages that sometimes people have claims for depending on how they were treated when they were let go. So, it's not just about base salary. There's a whole bunch of other things that can sometimes form part of the equation when you're looking at a wrongful dismissal claim, depending on the context. So, like I said, when we work with a client, what we normally do is first help them identify, okay, here's what your rights are, here's what claims you have, and here's how credible they are or how likely you are to be successful. And from there, what I'm going to talk about next is, okay, well, what do we do with that information? And frankly, it's going to depend on your context. Sometimes we do that assessment with somebody and we say, okay, you're entitled to 6 months. And then we go back and we look at the termination letter that the employer provided and they're offering 6 months. And we sort of go to the person and say, you know what, our recommendation to you is you sign the termination letter back and you accept the severance package that's on the table and you move on with your career because they're actually providing you, the employer's meeting its legal obligation to you. We don't have to do anything here. But in a lot of cases, employers don't do that. Employers, frankly, usually try and nickel and dime people the first time around. They'll try and get a deal on the severance. Or what they assume is most people won't go get advice and won't realize that they might be entitled to, 18, 24 months of severance and go, you know what, I bet you if we put a year of salary in front of this person, they will sign a release and go away. And sure enough, a lot of people do. They don't get advice. They might be entitled to 24 months and they just sign on 12 months because they didn't know to go get that advice. So if we're in one of those situations where we're looking at the severance package and it's unfair, these processes usually follow a pretty standard pattern, which is somebody will get that advice from a lawyer and then they'll retain that lawyer to send a letter to the employer that says, here's what my client is actually entitled to, pay them that amount of money. And frankly, a lot of employee-side lawyers, we probably start a little bit high to leave a bit of room for negotiation. The employer then comes back and says, you're out to lunch. I don't know what you're talking about. We don't owe this person anything. But in any event, here's a counteroffer that's maybe not what we asked for, but is somewhere in the middle. And then usually there's an informal negotiation that plays out over, usually 2 to 4 months, depending on the employer. And most employment law disputes actually resolve through that process more often than not. I'm willing to guess it's 70-80% of employment law disputes resolve through that process. The reason that they resolve is because litigating against your former employer is expensive. And you do not recover your your legal cost. It might cost somebody, $50,000 to $100,000 to bring a claim against their old employer, and if they're successful, they're only going to recover, somewhere between 2/3 and 90% of their legal fees. And so they need to be thinking about that loss, that financial loss on their legal fees, if they decide to push it further, and really would only push it far in a situation where an employer is being truly unreasonable or taking a really, really hard position about the entitlement to that person. But the other reason it settles is because of the duty to mitigate. Like I said, if you find a new job, the value of your claim can really erode and disappear, such that, maybe I'm entitled to 18 months, but I'm going to accept 14 because it just frees me up to go take a part-time job, do consulting work, go do, not have to look for work at all. Maybe I want to spend some time with my kids or do something different. It just sort of unburdens people to do a little bit more. So most things resolve through that process. The cost of doing that, our firm does not take these types of files on contingency or on spec, which is where, we don't get paid unless you get paid. The reason we don't do that is, frankly, it costs people way too much money. They usually take a percentage, and it usually ends up being, $10,000, $20,000 of the person's recovery. Because, if you get somebody who's entitled to 2 years of pay, like it can be a percentage of a fairly large amount. However, the actual cost of trying to negotiate these things without suing someone is in the thousands. It's in the $3,000 to $6,000 range. And I tell almost every new client when I'm in this situation, I expect we could probably resolve this in the range of $3,000 to $6,000. It's not always that much. It sometimes goes over that. There are files that prove to be more complicated than we expected. There are employers that are more unreasonable than we expected. Sometimes clients don't share all the information with us, and that sort of all of a sudden we learn that the file is more complicated than we expected. But most files fall within that range and within that pattern, and so that's part of the reason why we don't like to take these on spec or on a contingency basis. Is it just you're paying us to be your bank, and law firms that do that just take far too much from their clients' pockets. So that's why generally we don't run files that way. In terms of thinking about whether or not that's something you'd want to do, you're going to want to weigh the benefits and risks of doing it. The benefits are you might get more money. Even if you don't get more money, maybe you feel sort of assured that, well, at least I gave it a shot, so that if you're signing away your rights, as in you're signing a release which says you're not going to sue the employer and you can't do anything about your termination anymore, at least you can kind of go to bed knowing, well, I gave it a shot, and even if it didn't get anywhere, although I would say it's very rare that happens, because usually if we don't think the employer's going to improve the offer, we tell you that, and we say, look, we don't think you should do this, or the employer's being fair, or whatever. But like I said, sometimes there's unreasonable employers out there, and maybe you ultimately decide to accept the offer anyways. But the risks of doing so are also fairly minimal. Usually what happens if we send a demand letter and the employer is not willing to move, they just say, look, we're not willing to move. The offer we made on termination is the offer. And so other than the legal fees you're out from having sent the letter, you're still in roughly the same position you were in before. One risk is your duty to mitigate. So again, let's say the employer offers you 12 months on termination, you send a letter, and then 2 months post-termination, you find a new job, and the employer finds out you have a new job. All of a sudden, the employer is not going to pay you 12 months anymore. They're going to pay you your Employment Standards Act statutory minimums, and no more than the 2 months you were out of work. So that's one of the weirdest risks of working with somebody who just lost their job, is telling them that their biggest risk is they're going to find a new job. But it is the reality. It is just the way the law works, and so it is something you have to be attuned to. Some other risks, some people care about their professional reputation, and we don't act in a way that would ever jeopardize somebody's professional reputation, but they might go, you know what, I was just let go from this employer. I've been there for 24 years or a long period of time. They've offered me, 18 months, and I actually think I might be able to do some consulting or have some future business relationship with them. Maybe I don't want to send a demand letter or a lawyer's letter that says you treated me unfairly on termination because I don't want to sort of burn any bridges. So sometimes people are thinking about their professional reputation or their risk. Like I said, that's probably an exceptional case. It's rare that when somebody is let go from an organization that they're going to have a continuing relationship, but for some people that is definitely the reality, and so it's something to be aware of. But generally, the risks of trying to negotiate things are low, and frankly, most employers are expecting that people are going to try and negotiate an approved severance package. It is why they lowball. They hope that most will just sign off on the severance package that's offered, but they also know that a good chunk of them are probably going to send a lawyer's letter back, and they want to leave themselves some negotiating room. And so the risks are fairly low. The cost tends to be low, and the benefit does tend to be high. And like I said, that process is usually able to be resolved in like 2 to 4 months. And to be clear, that's not because of delay on our end. That sounds like a long period of time, I'm sure, for those of you on the call. It's just from a legal sort of, for lawyers, 2 to 4 months is not very long. And generally what happens is we meet with you, we'd get a draft letter put together pretty quickly, try and get it out within a few days, usually of us meeting with you. But then we would give the employer a week or two to respond to it. They inevitably ask for an extra week or two, and then they inevitably get further delayed. And basically your only remedy to sort of speed them up is to sue them, which costs in the tens of thousands of dollars. That's where this process gets really expensive, is when you're actually litigating against someone. And so our advice to you ends up being like, look, we're probably going to have to tolerate a little bit of delay here, but we'll stay on top of them, and we'll keep pushing them for an answer. And fortunately, especially for those of you in Ottawa, the employment bar tends to be very collegial. We deal with each other a lot, and lawyers don't want to get that reputation as the person who never responds to people and is always late and whatnot, because you're seeing the same people all the time. So it's not that the delay tends not to be too bad, especially when you're dealing with Ottawa lawyers. But unfortunately, that's not always the case. But that's usually how the process works. We'd send the letter, they'd come back, we'd sort of engage with informal negotiations, usually a few phone calls with the other side, and more often than not, we would get a deal. We'd get a negotiated deal. You sign on the dotted line, and you're able to kind of move on without ever having to sue anyone or get involved in the justice system. For those of you who are not that lucky, which again is probably 10 to 20% of cases, your options are usually just to sue the employer at that time. And whether that's a small claims court action or a superior court action or a human rights claim to the Ontario Human Rights Tribunal is going to depend on your specific situation and your specific circumstances. But I will say, if you're working with a lawyer, your costs are no longer in the thousands, they're in the tens of thousands when you're talking about any type of litigious forum. And so if any lawyer you work with before they sue should walk you through here's what you can expect the cost is, here's what you can expect the benefit is, and here's what you can expect the risks are. Some of the risks are you don't get your full cost paid, and if you lose, you might end up paying the other side's cost, although there's ways you can mitigate that risk or lessen that risk, especially in an employment law case, because courts don't love to award costs against employees if they can avoid it. They do know that there's a big power imbalance between the employer and the employee. There are also other ways to mitigate the risk, including sort of expedited or simplified procedures that let you get to a judge a little bit quicker. Because right now, if you're needing to take your matter to a trial, you're looking at probably 3 to 5 years to get in front of a judge. And so there are other processes and more straightforward cases to get the dispute in front of a judge much, much quicker. There's something called summary judgment motion, and basically it's a way to get your claim in front of a judge in a year to 2, which again is a long time. It's longer than it should be, but from as far as the way the justice system works, it's really not too bad. But the other sort of big risk when you're litigating or you're going to trial, on top of the cost, is just you're putting your case in the hands of a decision maker, and appeals exist for a reason, which is decision makers get it wrong all the time. I have failed at the first level and won on appeal. I've won at the first level and lost on appeal. Like that happens to lawyers all the time. That happens to cases all the time. And so you want to be very, very careful about ever taking your case in front of a judge, because you are just then, as good as our judges are, you're still taking a big risk that the person's going to agree with your worldview, and that's not always how things shake out. So in terms of how these processes work, that's really it. It's somebody's let go. We look at the package. We try and give you an assessment of yes, it's fair, or no, it's not fair. If it's not fair and you want to do something about it, usually we send a letter that triggers a without prejudice negotiation. We try and resolve it. And if we can't resolve it, your option is usually to sue in some way. But all the way along, whoever you work with should be explaining to you the cost, the risk, the benefit of each one of those steps. And just because you send a letter doesn't mean you're going to the Supreme Court of Canada if you can't get this resolved. There's always exit ramps throughout this process. So that was really what I wanted to sort of cover. I have the questions that people sent in before, and I can sort of go through those. But if any of you who are on the call do have any questions, feel free to just open up the Q&A button at the top, write it in that, and I will address those. There was a question about layoffs where if somebody, if a company lays everybody off but keeps benefits going, what are the severance obligations? If the company is now posting to be sold with all furloughed employees still on temporary layoff, who pays the employees? I want to be a little bit careful because that's getting into the weeds of like legal advice as opposed to legal information, but I think I can kind of high level at least cover some of these points. So the first issue is a layoff. At law, it is difficult for an employer to lay off an employee. And what most courts have actually said is a layoff is a termination, and it does trigger severance entitlements. There are exceptions to that, but the exceptions depend on what's in your employment contract. And so given I haven't seen this person's employment contract, I can't say whether or not they can legally be laid off because I don't know what's in the employment contract and whether or not that's the case. Also, it depends on, is pay and benefits being kept in place, but they're not working, or have they truly cut off the pay? Really what that amounts to is some courts have said that could be a constructive dismissal, which triggers severance entitlements. In terms of the sale of business question, I'm going to give you a very lawyer. It depends, because there are different types of sales of business. And again, I don't know what kind of sale this is. But if it's a share sale, so a corporation has all of its shares and the shares are owned by the shareholders. If, I own all the shares of my company in, Andrew Incorporated, and I sell them to Hannah, and now Hannah owns Andrew Incorporated, all of the employees go with the shares because their employer is not me as the shareholder. Their employer is the corporation. And so if I'm just selling the shares of the corporation to Hannah, there's been no change in who your employer is. And so you just carry on your employment through that sale of business, even if it's 100% of the shares and it is a true sale of business. Your employment's going to transfer. However, there is a different type of sale, which is called a asset sale, where instead of me selling all the shares of the business, I keep the shares of my corporation, but I sell all of its assets. I sell all of its IP, its machinery, its leases, its sort of tangible assets to Hannah. Hannah is now taking over control of this new entity through, Hannah Inc. And Hannah Inc. is now your new employer. And so that triggers a termination, because all of a sudden, instead of being employed by Andrew Inc., you're employed by Hannah Inc. And basically, since slavery was eradicated in Canada, hundreds of years ago, courts said, hang on, we can't sell a group of employees from one employer to a new employer. That's illegal. That looks like human trafficking. And so it actually is a deemed termination. But there are laws in place that still allow it to happen in different ways. So for some rights, it might be a termination, but some rights are going to carry over to Hannah, because what a court doesn't want is they don't want you who worked for Andrew Inc. for 20 years, and for factors beyond your control, you get moved to Hannah Inc., and all of a sudden you lose all your years of service. What the law says is, nope, Hannah has to honor your 20 years of service with my corporation. So there are funky rules when it comes to sales of business and what the obligations are to employees. Those rules depend on what the sale of business is. They can depend on what your employment contract says and things like that. And ultimately, who ends up being responsible to those employees is going to depend on the type of sale of business. Is it an asset sale or is it a share sale? So hopefully that kind of gave whoever asked that question some information. But again, I think you would need specific advice. One person asked me to address contracts that waive your right to common law notice, and then specifically asked me to provide feedback on a specific clause. So in terms of providing specific feedback on a specific termination clause in a contract, that is legal advice. So I can't do that. I haven't run a conflict search. I don't know who this person is. We could be representing your employer. We could be representing your manager in some other family law proceeding. And so that's why we can't give legal advice, is we haven't done a conflict check to make sure we're not in a conflict from giving you advice if we're already acting for someone else. However, addressing contracts that waive your common law or other severance, I've already kind of talked about that, but to just make sure I've clearly addressed it, you can always contract above the Employment Standards Act, but below the common law. That's perfectly permissible. Or you can contract above the common law. That's perfectly permissible. The caveat to that is if an employer does that and there is any defect in the contract, what a court will say is that contract is entirely void and that person gets common law. So that's really how those contracts work. Courts will enforce contracts that waive your right to common law. They're comfortable with that. However, it has to be clear. It has to be clearly above your Employment Standards Act amounts. And again, in terms of giving advice on specific clauses, you need to seek your own individual advice for that. One question was, if a severed employee wants their legal representative to negotiate a severance package on their behalf, how do you negotiate a good offer beyond the minimum entitlements in common law? What are some things employees should look out for? So I thought that's a great question, because what is a good offer is going to depend on you. I will regularly have a bunch of clients who are very similarly situated that have very different expectations for what they want. One person might feel like they're going to find a job really, really quickly, and they want to just get a quick deal. And so what's fair to them is just getting, something signed off in a month or two so that they can move on to their next thing and not have the duty to mitigate get in the way. For somebody else who they just go, the job market is terrible right now. I don't think I'll ever find a new job, and I don't like the way I was treated on the way out. To them, a good offer is something that is a longer notice period, pays some bad faith damages, pays some other things. So you need to be careful about what's a good offer, because a lot of it's going to depend on you. Another might be your risk aversion. There are some people who are willing to throw money at a lawyer or pay a lawyer to try and negotiate an approved package, knowing that they might not get where they want to go, but they just go, look, I can afford this. This is fine, even if the employer doesn't improve the offer as much as I'd like. I'm comfortable with that. Where for somebody else, they might go, I'm not willing to pay that money and run the risk that I lose that money. So what's a good offer for those two people is going to be fundamentally different. In terms of things to look out for, though, well, first of all, what's a good offer is we'll help you figure out what a good offer is by talking about those things. When do you think you're going to find work? Do you want to look for new work? Do you think you're going to get a job soon? How are things going with your job search? We'll help you figure it out, and what's good is going to depend on a lot of those things. But in terms of other things you might ask for, because they said non-salary benefits. So I already talked about some of the things that are non-salary: commissions, RSUs or equity benefits, things like that. Car allowance, clothing allowance. But there might be some other things too. Retraining, some people ask for, of let's say you have very specific skills that are now outdated and you need to take a couple college courses to get sort of caught up. That might be something you ask for. Outplacement counseling. There are companies that help people find a new job. There's a lot in Ottawa. There's some really great ones. There's Clarity. There's Career Joy. There's a bunch of really, really good companies in Ottawa that provide support for people. You can sometimes negotiate that the employer pay for that for you. Optimum Talent is another one. Anyways, there's a whole swath of these companies that do really good work with people who are looking for a new job. But yeah, sometimes they will pay for that. Your legal fees. We can often negotiate payment of your legal fees as part of a severance package. Employers don't always agree to pay it, but more often than not, they do, and often people get 100% of their legal fees paid when we're getting this resolved. It's also, again, one of the reasons why we don't like to take speculative files or contingency files is the fact that we know that usually the employer will pay. And so instead of us taking a chunk of your severance to pay your legal fees, we know that there's a good chance we can get it as a separate amount so that you get to keep as much severance in your pocket. Because, ultimately a severance package is a big pile of money that people are entitled to. And our job is to keep it as big as possible for you. And if we're through legal fees chipping away at that, then we're not really serving you well, and we don't want to do that. Um, but those are the types of things that you might negotiate. Also, references, written references, getting a confirmation of somebody who will provide a positive oral reference if needed. That's another thing that you might try and negotiate. Um, another question was, what if somebody's laid off as a salesperson for non-performance, for example, if they don't reach a sales target? What I think that person is getting at is can an employer fire them for cause? And the answer is probably not, but it would depend. For firing someone for performance for cause, it's a very, very high test. It requires warnings. It requires performance management. Like there's a bunch of stuff that an employer has to do before they can assert cause for performance. So that would be very difficult to do. But if they just want to terminate them without cause and pay them severance, like I said, you can terminate virtually anyone under the sun for virtually any reason under the sun, so long as you pay them severance. And so if they don't like the performance and they don't performance manage you and they just go, you know what, this isn't working, we're going to get rid of that person, that's probably fine as long as they pay you severance. Finally, there was a good question, which was, can you negotiate your job loss upfront as part of a job offer? And the answer is absolutely you can. And we actually see a lot of people like that. Usually the people we see like that are the ones who have been through a termination once before. We tell them they have an enforceable employment contract and it is providing them a lot less than they expected. So they kind of learn the lesson of like, oh, maybe I should have thought about this proactively when I got this job. But when you're negotiating a new employment contract, you can negotiate your severance entitlement, and we often do help people negotiate that to try and get it somewhere north of the Employment Standards Act amount. I was helping someone literally last week with that. It's a very common thing that we do. It's just something that a lot of people don't pay attention to. They focus on the vacation days, they focus on the benefits, they focus on their salary, and often sort of see the legalese around termination and just sort of skim over it, not realizing they've just agreed to an employment contract that significantly limits their entitlements in the event that they're terminated. So those were all the questions that we got in advance. I'll give like another second just in case anybody who is on the call does want to dump another question in the chat. Otherwise, that's really all we got. Hannah, maybe I can hand it over to you, but if you do have any, questions about any of this, if you want your own advice, Hannah will provide you some information on how you can reach out to our team. But hopefully none of you do. Hopefully this is all sort of in advance, but if you are in that situation, we'd be more than happy to help you. We help, every day we help guide our clients through this situation, and it is very manageable. It's not too stressful to deal with employers, and we really try and sort of take a lot of that stress off your shoulders so that you can kind of just deal with looking for a new job, thinking about what your next career move is going to be, while we worry about sort of what the fallout is from your past employment.
Thanks, Andrew. So, like Andrew said, just a few kind of logistics about sharing the webinar. I mentioned this at the beginning of the session, but we will record this session. So if you maybe arrived a little bit late or you missed something, you'd like to rewatch it or you'd like to share it with someone you know in a similar situation, I'll be sending an email to all the registrants shortly with both the recorded webinar. Any participant names and information obviously will be blocked out, so you don't have to worry about any of that privacy stuff. And then additionally, in that email, I'll share Andrew's contact information and then also the contact information for our employment law intake clerk. So if you did want to move forward and get in touch with our team about potential legal advice, we have a fabulous employment intake clerk. Her job is just to be the first point of contact with people coming to our employment team. So it's free to meet with her. She just basically learns about your situation. If you do choose to move forward, she'll match you up with a lawyer that would be a good fit with you. So I'll include all that information in a follow-up email. And again, thank you so much for attending. We appreciate it, taking time out of your day. And yeah, we hope you found some helpful information in this session too. And thank you, Andrew, for presenting. So I will end it here and hope everyone has a good night.